Well, thank you for joining us. We are now in episode number 2 on non-competes with Karl Ulrich at Sebaly Shillito and Dyer. Where did we leave off, Karl?
Wow. Things have been moving very quickly in this world, haven't they? Last time we talked, I think we were talking about the new Federal Trade Commission rule that came out, the final rule which invalidated some employment non-compete agreements, actually pretty much all of them. And it was a kind of watershed event, and a lot of employees and employers were kind of wondering what was going to happen to that rule, whether there were going to be court challenges, and what would occur as a result of those court challenges. Well, we have now a little bit more clarity on that. Very recently, some courts have ruled, so we can talk a little bit about where that stands and what happened to the FTC rule on non-competes.
Well, let's start at the beginning for those who missed our last show on this topic. The Federal Trade Commission is not normally what we think about in terms of a government agency that would, I don't want to say guide, but even really mess in the arena of employment and labor.
That's right. Federal Trade Commission typically handles commercial issues, and one of the areas of the law that the FTC weighs into very heavily is antitrust law and unfair competition. So the FTC was designed and created to make sure that the economy ran smoothly, that there was adequate competition, that actions involving restraints of trade were regulated and limited. And so the FTC was originally tasked with those areas of enforcement. And they didn't weigh into, as you put it, they didn't step into the employment arena very often, although the most recent FTC rule that we're going to be talking about today is not just a step, but kind of a leap into that employment arena.
Yeah. In fact, I think when we talked about it in general terms, we kept thinking the National Labor Relations Board was going to come in and make a real stance, because General Counsel has not been quiet about that.
No, you would have expected the Labor Board to be kind of at the front end of that. Now, the Labor Board has done some things and has talked a little bit about restraints of trade in other contexts, but not to the degree the FTC has. The FTC is really, in the form of this final rule, has really stepped into this arena with both feet, and it was inevitable, I think, that there would be some court challenges to the rule. As a lawyer looking at the scope and breadth of the rule, the impact of that rule on businesses as well as employees, it was probably inevitable we'd see some legal action. And so we have, and we can talk a little bit about where that stands right now. But one way to start may be to just kind of do a quick recap of the FTC rule. What did it actually say?
Sounds great.
Yeah, the FTC came out earlier this year with a rule that said that non-compete agreements in the employment context, and in other contexts as well, but most non-compete agreements were deemed to be unenforceable restraints of trade, were unfair competition. So when you have an agreement with an employee that says upon termination you're not allowed to compete with the former employer for a period of time in a certain geographic area, that's a typical non-compete restrictive covenant that you'd see in some employment agreements. Fairly commonly used in many industries with many positions. The FTC has been looking at that for quite some time, but they came out with a final rule this year that said most non-compete agreements, particularly in the employment context, would be deemed unenforceable. And there were some exceptions to that, but you can't enter into a non-compete agreement. You can't enforce previously existing non-compete agreements in the employment context. Some minor exceptions, but for the most part, they passed the sweeping rule that threw most of these agreements out. And a lot of businesses had, business models based upon that kind of protection. So it was a rule that was bound to get challenged. So that was where we were early this year, the spring. We predicted, I think, that there would be some legal challenges to that rule. And there were, in fact, several court cases were filed across the country. And one in particular that we watched very closely was a case in the district court, federal court in Texas. Texas, by the way, seems to be the place where folks go to litigate cases involving allegedly executive overreach. And in fact, they filed here. So the Texas court looked at this issue, tried to determine whether or not the FTC rule overstepped the agency's authority under law. And that's what the litigation was about.
Well, and that's kind of, I think, where we left off.
Yeah.
Was there was so much, we were waiting, and we knew that, to your point, there was somebody, but Texas, I mean.
Yeah.
And then followed up by Pennsylvania. Share with us how different those two perspectives were.
That's a great point. So the Pennsylvania court actually upheld the FTC rule. Totally different result than the one we got in Texas. Now, different courts, different judges, different backgrounds, different parts of the country. But this is the challenge, of course, when litigating these issues. Now, you only really need one federal court to put a hold on the rule in order for it to be held up. So the Texas court in the end of August made its long-awaited ruling, and the judge had kind of hinted at this earlier on in a couple of other filings, but the judge in the Texas court said, no, the rule as the FTC has promulgated it exceeded the FTC's authority under the law.
A lot of businesses were happy about that.
Yeah, yeah. A lot of them were. Now, so the court basically issued what's called an injunction, basically a full stop on the enforcement of the rule. And so for now, at least, the FTC rule's on hold. We don't have to, if you're an employer, you don't have to worry about the enforceability of some non-compete covenants. If you're an employee, you're basically the way the agreements were as valid as they were before. No change in status there. So, but that may not be the end of the story.
Well, and take us back to Texas, because Texas dug in so deep. So today, which is September 12th, 2024, are the non-competes on Texans, individuals who reside in Texas, are they still in? I mean, they're no good.
The FTC rule's been thrown out.
Okay.
By the Texas court. The injunction applies nationwide.
Okay.
So basically what the FTC rule said was non-competes aren't enforceable. Court stepped in and says, no, we're not going to allow the FTC to impose this rule, meaning in effect that it's status quo ante. The enforceability of non-competes are as they always were before the FTC ever came along. So for now, at least, we can ignore the FTC rule, but we still have to keep an eye on it because, as we all know, the district court is just the first level of the federal court system.
Right.
The FTC has already indicated that they are seriously considering, I think were the words they used in their response to the court ruling, an appeal. Now, that would go up to the Fifth Circuit Court of Appeals. The Fifth Circuit Court of Appeals tends to be a more conservative court, tends to be a little bit more deferential to, well, let me put it this way, it tends to be a little bit more reluctant to expand government authority in some ways, not always.
Okay, we like that.
But so there's a pretty good chance, at least in my humble opinion, that the Fifth Circuit will uphold that decision by the district court. But even that might not be the end of it.
Well, more than anything, because we've got viewers all over the country, some even outside the United States, we have to remind them that they need to follow the state laws.
Mm-hmm. Yeah. So taking a step back, looking at this FTC rule, it's a very good point you make. The FTC rule was really an effort, among other things, to institute a uniform rule about non-competes across the country. Prior to this FTC rule, and now again, every state regulates non-compete agreements according to their own basic contract law, and that can vary from one state to the next. And some some jurisdictions limit non-competes already. California is an example. Other states, like Ohio, allow non-competes to be enforceable, subject to certain long-standing guidelines, but otherwise pretty much hands-off. So it is a state-by-state test, and you're absolutely right. So until we have a uniform rule, if we ever have one, it's going to be a state law question.
So for those companies who are standing here going, look, I'm tired of the flip-flopping. I want something that's progressive enough that I can use no matter where they're employed. And that's almost impossible. You and I both know that.
Yeah.
However, what would you say would be a best practice moving forward if they wanted to simplify their lives but still maintain and exercise some sense of control over the activities of what goes on during employment?
Yeah. I mean, what we do is we use these restrictions like non-compete agreements to protect certain employer investments, certain company business investments. We don't want employees leaving and taking those investments, those secrets, those client relations, whatever they are, with them and setting up a competing business after they've worked for us and had access to all the stuff that we developed. That's the basic idea. And I think those restrictions, there are still some restrictions that you can utilize, whether the FTC rule survives ultimately or not, or some version of it survives ultimately or not. There are going to be other restrictions that you can institute, you can put in place in contracts if you're an employer that will provide you with protections that are a little more tailored and a little more narrowly construed than a non-compete would be, but would pass muster, would be legally valid regardless of what happens in the FTC context. So one of the things I think employer entities should look at is whether there are other less restrictive, less onerous, and a little bit more tailored solutions to that same problem that don't involve this very controversial and still uncertain FTC issue.
Yeah, it's amazing because there was so much confusion. Those who were under non-competes were throwing parties and saying, I can go anywhere I want to go now. And the employers were going, oh, no, I can't let this individual go and work for my competitor. And then there were other people who were just indifferent because it really didn't matter. They were at a level of a position that really didn't have anything to protect.
Right.
And so it affected business in so many different ways. This is probably one of the most controversial topics that we've had since we've been working together, for the past 7-8 years.
Yeah, and I'm a management side labor lawyer, but I'll tell you that it also affects employees, and it affects them in ways that I think sometimes hard to identify. And for folks who are not at a high level in an organization, a non-compete can be a pretty daunting, very very worrisome thing, and so. I think for employers who are using this type of legal protection, this type of contract, I think it really makes sense for them to be really thinking about where it's appropriate and where it isn't. Non-compete isn't appropriate in every case. Even if you're an employer and you want to lock up and protect your trade secrets and your proprietary information from theft or from departing employees, there are certain situations where it's just simply not appropriate. And others where I think the justification is much stronger. So I think being a little more careful about how we apply these restrictions going forward is a best practice, using non-solicitation in lieu of non-competition agreements.
That was going to be good.
That's another best practice.
Good.
And emphasizing confidentiality of trade secrets and proprietary information is another best practice. And now you can do all of those things in a more limited and a more targeted way, and I think that will be much more likely to withstand scrutiny in the future.
And the sad part is, as we have told them over and over and over again, there are certain things within employment and labor that have to be legally binding.
Right.
They can't be pulled off the internet. They can't be just written based off of something someone's seen or used in the past 5-10 years. And this is a really good topic to include that. Right. Non-competes, non-solicitations, even confidentiality statements. Viewers, please partner with your labor law attorney. Call Karl, but make sure that whatever you put in place in this arena of discussion and within your employment practices, that it's legally binding and that it's going to protect you moving into the future of business. Karl, thank you.
Thank you. Thanks for having me.
And thank you for watching. Come again to the Human Resource.